so we'll be ready to proceed.
Okay, so I'll proceed now.
No, sorry. We'll wait for the clerk to make sure that we're live, and then he'll call the case first.
Thank you.
Okay, we're ready. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the single justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. The case is Appeals Court, docket number 2022 J0039, MTGLQ Investors LP versus Jeremy Darling and others.
Good morning. Mr. Maxwell, I will hear from you first regarding your position on this summary process bond appeal matter.
Your Honor, as far as I'm aware, I'm the only defendant in the case proceeding forward at this point. I have filed an appeal of a summary judgment in the lower court, and then we had an appeal bond hearing. I provided evidence at that hearing. Part of that evidence, which was allowed, was a indigent filing due to my financial situation. My financial situation has been impacted over the last 2 years due to medical expenses. I provided the defense at one time. I'm recovering from a broken right leg, which had a hematoma, and I've experienced edema, and I have a restricted ability to work. So, Your Honor, I've been unemployed. So I have limited ability to work, and I've had other medical expenses. I'm a diabetic, and I've had an impacted tooth extracted recently. So I have very limited financial means, Your Honor. This limited financial means was presented to lower court and was not taken into consideration. The lower court used my public assistance to determine I had a salary which would allow me to pay a substantial bond amount. It exceeded $20,000, which I don't have, and also ordered that I pay $600 a month in rent. I appealed that bond decision to the higher court, Your Honor, and the higher court recognized my indigency and remanded the order, had a remand order back to lower court to reconsider. The lower court judge conducted a hearing. At first, she was unaware that the case had been remanded back down to her. So she became educated at the time, and she disregarded or did not reconsider the bond as ordered by the higher court, and let her original order stand as it existed. When the higher court remanded the case back down to lower court, it allowed me to reappeal, which is what this appeal is, if the lower court did not take action on its order. So in the reappeal, Your Honor, my financial situation has continued to deteriorate, and I don't have the legal means to pursue the due process aspects of my appeal. I believe my appeal has merit.
So why don't we get to that? What are you going to be arguing on appeal?
Right. So in addition to this case, Your Honor, there was an earlier U.S. federal court case regarding the foreclosure on my home. And that case was dismissed by the First District Court of Boston. During the court hearing, the trial judge for the summary judgment had stated that she was not going to allow evidence to be allowed regarding that case. However, when she concluded her summary judgment, she included it in the basis of fact for her judgment. So we have an appeal of good faith that the record of the actual trial does not match the basis and the decision-making that was conducted in the summary judgment. I also have subsequently filed a new court case, which in my opinion, is different from the first. The first court case consisted of, in the U.S. federal court, consisted of the foreclosure matter. Since then, January of last year, the Massachusetts Attorney General's office conducted an investigation of Shell Point, or the subsidiaries of Goldman Sachs, which is the financial group involved with this property, and concluded, the Attorney General's office concluded there was substantial fraud in the Consumer Protection Acts of Massachusetts. They reached a settlement with Goldman Sachs in which I was paid a settlement amount, which was a portion of what the state of Massachusetts received, but did not limit me to the settlement. So I have filed my own case in Barnstable Superior Court, which the defendant has appealed or withdrawn to the First District Court. Now, during that process, the defendant changed the nature of the case. I filed the case based on fraud and tort and fraud, and it was mostly based on the Attorney General's Office of Massachusetts case and evidence, which was new evidence that I came across last year. And that case is now being appealed at the First District Court in Boston. I believe the defendant has a response due by February 7th to my brief I filed pro se. Also, due to my deteriorating financial situation, I had to terminate my association with my former attorney, and I'm now representing myself pro se. So I'm in a very tight situation. I cannot afford the erroneous over $20,000 bond to continue.
Why is that erroneous?
Because in the bond hearing, the trial judge did not allow my attorney's objection filing because he filed it the day of the hearing, but he did proceed to verbally present it during the hearing. And part of that case was I am one of 5 occupants of the property. The bank, which is a substantial bank, has not seen the need to collect rent or occupancy from the other 4 or 5 occupants which live there. So there is a unequal application of the needs in the financial situation with this case with the other defendants, which are no longer part of this case. They reached an agreement, and as part of that agreement with the defendant, the plaintiff, the other defendants, the 4 out of 5, have no legal economic obligation to pay any damages or any back rent. I am the only 1 out of 5 where the bank is requesting back rent, bond, and security and rent going forward. So there's
Are they still living there?
Yes, ma'am. I occupy a room in part of the garage, 1/5 of the area of the house. So we're co-occupying the house. I use one room in storage space in and above the garage. The other 4 occupants occupy the majority of the property. So the bank is not in a financial situation where they need the money, and they've allowed the other 4 or 5 to basically walk scot-free, and they're only seeking financial compensation from me.
They're only seeking compensation for your portion, right? For the portion that you occupy.
Correct, but they aren't seeking any compensation for the other 4/5 of the occupation of the property. So there is no need that I see from the bank, substantial need, financial need, and there'd be disproportionate application of need between myself and the bank, whereas I am in medical and financial distress, and the bank is not, and the bank has shown it is not in immediate need of this financial resources. The property continues to significantly increase in value, probably 20% over the last year would be my opinion or estimate. And ultimately, the bank will sustain no significant financial impact whether or not back rent is paid, based on their demonstrated lack of need with the other occupants and the current market where the value of their interest has gone up significantly since any of this action started. So as part of my medical COVID, I've had the broken leg, which has been impacted by my diabetes. I'm over 60, I'm a senior citizen, and I have a limited ability to work. I've received government assistance, and I don't have the means to pursue my case on appeal based on the conditions of the lower court. In the lower court,
Can I ask, when you say you're on government assistance, is that unemployment, or are you referring to something else?
right, I've applied for and I'm receiving Social Security at this point in time, Your Honor. That's my only source of income right now.
Okay, and when, in terms of your issues for appeal, do I understand that it's because you have one or two cases that have at the trial level been decided against you but are currently on appeal
Well,
regarding
the other issues
ownership of the property?
in this case that are on appeal, that I've asked for appeal, is the plaintiff has requested a restriction of litigation order placed on me, saying I was an extraneous litigant. And so the lower court judge has placed an order restricting me to file in my case or defend myself unless I at first ask the judge for permission to file, which impacts my timeliness to abide by certain clocks and rules within the court system. The only exception to that is a filing to appeal. So I'm limited in my ability. My hands are tied behind my back. What happened was when I terminated the agreement with my former attorney, I needed to file court documents to bring my case up to date because I didn't feel my attorney was representing me adequately. And the plaintiff successfully argued in the lower court for the court to restrict my ability to file or address in the court, further impacting my due process rights. I believe that was due to the lower court judge being biased against me. She's the regional director for female judges for New England, and she's also heading a committee to inject critical race theory into the Massachusetts trial court system, which basically is biased against single white men in preference over people of color. So I received a very negative review in the lower court. The judge was biased. I asked her to remove herself, and she refused. And the result was the restrictive order on my ability to file within the court, her court.
So, but you do, I guess my question is, you do have an appeal pending?
Yes, ma'am.
Okay, which court is that in?
In the lower housing court, and of appeal pending in the U.S. federal court in Boston. For my federal.
Okay, and both of those have to do with ownership of the property?
The housing court has to do with ownership in the foreclosure process. The case in U.S. District Court is now a tort fraud case involving RICO against Goldman Sachs Bank.
Okay, thank you. I'll hear from the other party.
Thank you, Your Honor. As I'm sure Your Honor is aware by now, this is a post-foreclosure summary process action that has been anything but summary. This essentially touched at least 4 courts across this Commonwealth, including the Housing Court, Superior Court, Federal District Court, and the First Circuit Court of Appeals. After this action was essentially filed in May of 2018, foreclosure took place in December of 2017. In September of 2018, Your Honor, this action was stayed to allow Mr. Maxwell to file an action in Superior Court to challenge the validity of the foreclosure sale. That action ultimately wound up before the Federal District Court, was dismissed in February of 2019. That dismissal was affirmed in August of 2020. After that, the case proceeded again back to the Housing Court. My client moved for summary judgment in December of 2020. There was a hearing in May of 2020 judgment ultimately entered in July of 2020. After that, there were a slew of post-judgment motions that were filed by Mr. Maxwell after he terminated his counsel, as he mentioned. He also filed in September of 2021, Your Honor, another action in Barnstable Superior Court, again challenging the validity of the foreclosure sale, this time including a reference to what Mr. Maxwell referred to, which is an assurance or discontinuance that Shell Point, which is the servicer for the mortgage loan, entered with the Attorney General's office. Has nothing to do with this case, and I'll get into that in a moment, Your Honor. But the point being is that that case was, which was filed in September of 2021, was also removed to the Federal District Court. That case was also dismissed in November of 2021 on res judicata grounds. That dismissal is currently on appeal before the First Circuit. Mr. Maxwell has filed a brief. My client's deadline is pending. It'll be filed next week. That being said, with that all that background, what is actually in front of the court, as the court is well aware, is a relatively limited issue of whether Mr. Maxwell was entitled to a waiver of the bond pursuant to 239 Section 5E, and to the extent that he was or was not, whether or not the housing court correctly calculated the bond pursuant to 239 Section 6. As Your Honor also knows, to be entitled to a waiver of the bond under 239 Section 5E, that includes two elements. Mr. Maxwell must establish that he's indigent, which is a statutorily defined term pursuant to 261 Section 27A. He must also establish that he has a non-frivolous defense. That is a term that's defined by the case law, the relative case law, which more or less says that they have to go something beyond a lack of a meritorious defense, something that constitutes lack of a prayer or beyond an egregious lack of merit. To address those first issues, I'd first rather address the whether or not Mr. Maxwell has a non-frivolous defense on appeal. I think it's fairly clear, Your Honor, that Mr. Maxwell cannot assert a non-frivolous defense. And I say that for essentially four reasons, Your Honor. If you look at the background and the opposition to my client's summary judgment motion, which was filed back in December of 2020, there was essentially one issue that was raised by Mr. Maxwell at that time, and that was an objection to the documents that were included as exhibits. One of those objections was based on whether or not the copies were original certified copies from the registry. That objection was unsustainable, as the housing court addressed. My client did provide certified copies directly from the housing court, and those were admissible. So that objection was unsustainable. The second objection was relative to a reference to the loan number. Essentially, Mr. Maxwell was arguing that the documents included, the loan documents, notices of default, and et cetera, were not properly authenticated because the affidavit that was used under the business records exception didn't include the entire loan number. We're actually prohibited from using the entire loan number. There was clearly enough information in that affidavit and the documents themselves to properly authenticate them under the business records exception, Your Honor. So neither of those objections were sustainable. Furthermore, Mr. Maxwell offered no admissible evidence as part of his opposition to that summary judgment motion. There was no affidavits, there was no admissible documents, there was nothing that was presented other than essentially an objection to the documents that my client presented. As Your Honor knows, once my client presented a certified copy of the foreclosure deed and affidavit of sale, my client has made its prima facie case of its superior right to possession of the property. It then became incumbent upon Mr. Maxwell to produce some admissible evidence to establish some defense. He did not produce any evidence to that. Furthermore, Your Honor, even if Mr. Maxwell had, the housing court correctly concluded that any defense relative to the foreclosure sale itself was barred by the doctrine of res judicata based on the federal district court's earlier decision in February of 2019, as affirmed by the First Circuit Court of Appeals in August of 2020. I'm happy to go through those elements of res judicata, but I know the court is well aware of them. Additionally, the federal district court has also determined that claims related to the AOD document that was entered into the Attorney General's office, that those have been also barred by the doctrine of res judicata in the subsequent action that Mr. Maxwell filed in September of 2020, which was ultimately dismissed in November of 2021, September of 2021, which was dismissed in November of 2021. So Mr. Maxwell presented no admissible evidence. His defenses were barred, and the evidence that he's trying essentially to raise at this point is not relevant to the action, has nothing to do with it, and is merely essentially trying to bolster allegations that have previously failed before the federal district court and have again failed before the federal district court now. So I think it's pretty clear, Your Honor, that Mr. Maxwell cannot assert at this point in time any defense that would pass the non-frivolous standard. With regard to the indigency, Your Honor, again, that's a statutorily defined term under 261, Section 27A. I would just like to briefly point out to correct Mr. Maxwell's characterization of the remand. I don't believe that the single justice of this court, when they remanded it back in August of 21, made any determination with regard to Mr. Maxwell's claim of indigency. I believe that that's better characterized as a request for the housing court to make a determination as to whether Mr. Maxwell may potentially qualify as indigent under the third definition contained in that statute, which relates to whether or not payment of the bond would render him unable to pay any of his other necessary living expenses. I would just say this, Your Honor, on that claim of indigency. I believe that the housing court correctly determined that based on his annual income, that he didn't qualify under the second definition of indigency. I think the third definition, Your Honor, if we were to apply that bond, my concern is that exception would essentially be so broad as to swallow the rule itself. If every non-payment was so substantial because the former owner had delayed possession for so long, I think a bond would render almost anyone indigent, and that would precisely defeat the purpose for which the bond statute was designed. But nevertheless, even if this court were to conclude that Mr. Maxwell does somehow qualify as indigent, I still don't think that he's passed the non-frivolous defense. So that goes to the waiver of the bond issue, Your Honor. With regard to the calculation of the bond, again, as Your Honor correctly pointed out, our request for the bond was not based on the fair market rental value of the house in its totality. It was only for the space that Mr. Maxwell occupies. To the extent that my client isn't requesting use and occupancy from the other occupants, they're not appealing it. We've entered into agreements for judgment for possession. They only remain in the property because Mr. Maxwell refuses to vacate. It's a single family property, so it's impossible for my client to obtain multiple executions. So long as Mr. Maxwell remains in the property, there's no execution that will issue. My client has no ability to move them out. Nevertheless, they're not appealing. So the bond requirement is based on Mr. Maxwell's appeal. It's not based on any need on my client. It's a statutory requirement that is triggered based on the fact that Mr. Maxwell is a former owner in a post-foreclosure action. It is appealing a negative judgment that was entered in a housing court action. So on that basis, Your Honor, I would ask that the bond entered by the housing court be affirmed. If anything, the bond was actually calculated in Mr. Maxwell's favor. Not that it's a substantial difference, but I would only point out that the housing court calculated from the date that the foreclosure deed was executed, which was January of 2018, whereas the foreclosure sale itself took place in December of 2017. My reading of the statute, at least of 239 Section 6, is that the bond is under the first sentence triggered from the date of the foreclosure sale, not the date that the foreclosure deed was executed or recorded. I believe there's the Minahan case, which also stands for the proposition, Your Honor. But nevertheless, we're only talking about essentially a 1 month difference. But as to the amount, I think the court was also very fair and reasonable in that. Your Honor, just to briefly review the record, my client had requested that the monthly rate be set at $800. Mr. Maxwell himself testified that he believed it was between $300 and $500, and the housing court set it at $600. So I don't think that there's certainly anything unreasonable about the amount. And Mr. Maxwell has certainly been able to pay the amount of the filing fee at the federal district court. He's been able to pay the filing fee at the United States First Circuit. I don't believe he's requested any waivers as far as his ability to proceed in those actions, Your Honor.
All right, thank you. Mr. Maxwell, I have I think, heard the parties at length, but I do want to give you an opportunity to give a brief response if there's anything that you'd like to respond to from the last comments.
Whether I have a frivolous appeal, Your Honor, or not, part of my appeal that I didn't discuss earlier was I requested the judge during the summary judgment to allow me to introduce additional information, which was the Massachusetts Attorney General's Office settlement agreement, which contained new information. I wanted to provide testimony and evidence. The trial judge refused my request to provide additional new evidence, refused to allow me to testify in that case because I had representation, my attorney. I requested my attorney to present that case for me on a sidebar. My attorney refused, and that was part of the reason I terminated my relationship with my attorney. He refused to introduce new evidence. I requested from the trial judge to be able to introduce that evidence, and she refused my request to provide testimony or new evidence. So when the plaintiff says I introduced no evidence, the reason was I was not allowed by the trial judge to introduce that new evidence. As far as the various cases, based on that new evidence, my case I submitted to the Barnstable Superior Court, which has now been withdrawn to federal court, involves fraud and tort, not real estate foreclosure. The plaintiff has changed the nature of the case when they withdrew it from Barnstable Superior Court to federal court without my consideration or approval or review. So the case being reviewed in federal court, I believe on my appeal, is tainted, in that the plaintiff changed the paperwork when they withdrew it from the Barnstable Superior Court to the federal court, which I don't believe is correct. So there was that new information. So I don't believe my appeal is frivolous because it's based on my due process rights to provide testimony and new evidence, which wasn't allowed. And the trial judge during the trial in the record stated that she was not going to allow or take into consideration the evidence that the plaintiff just gave you as far as the federal case being dismissed in federal court, the particulars of that. I'm not an attorney, so I cannot rebut the particulars of what the plaintiff has told you, but my attorney provided a rebuttal to that as far as the details. The fraud that I'm alleging in my case is that the Massachusetts Attorney General's office found that Shell Point Mortgage, which is associated with that, did not have proper procedures, and they were a plethora of pages of fraudulent activity on how they were applying Massachusetts consumer protection laws for banking. Also, Shell Point, which is the plaintiff, they weren't licensed to provide the mortgage modification program. I applied for 3 times for mortgage modification, and they lost the paperwork. Well, I found out later that the reason it wasn't considered was they weren't licensed to provide it in Massachusetts. And the reason they were offering it was they have a non-third-party agreement with the U.S. Justice Department to provide mortgage loan modifications as part of the financial disaster in 2009. Goldman Sachs was a prime instigator and litigant in the financial collapse of the system in 2009. The Justice Department was considering indicting them under criminal charges. Since then, they've gone on to bribe foreign governments. They have bond cases around the world in which they've in lieu of pleading guilty, they've paid substantial fines, something like over $20 billion for criminal activity worldwide. And the institutional governmental, the government of Indonesia's sovereign bond fund was being raided by Goldman Sachs. It's public information in the Federal Register. They paid multi-billion-dollar fines for bribing Indonesian government officials. They tried to steal all the retirements of the people of Indonesia. And the Massachusetts case is just a small subset of their inappropriate, unethical banking behavior, which the Massachusetts Attorney General's office proceeded. In addition, I made payments to them to try and bring my mortgage current, which weren't applied and weren't allowed and returned to me. So this evidence was not allowed. I was not allowed to present or give to the lower courts, part of my appeal. It's part of why I revised my federal court case as a RICO Act. It's just incredible. This banking is a criminal, international criminal banking system. Well, I'm sorry.
So I understand, I think I understand the basis of your, what I was trying to make sure that I understood was the basis of your appellate argument.
Let me apply the financial aspect, Your Honor.
Your Honor, I think this is, with all due
I
respect.
need to.
I think you've gone on long enough.
Okay, counsel, just a moment. Mr. Maxwell, as I had stated, okay, I wanted to just give you an opportunity to respond to what the attorney had stated. You had a full opportunity to state your position to begin
Well,
with.
Your Honor, can I have one more additional minute to address the financial money aspect of it?
Your Honor,
What do
I'm
you
going
mean
to object to that.
what do you mean the
That has nothing
financial
to
money
do with this
aspect?
case.
The bond amount. Your Honor, I did agree that I could pay something per month rent going forward, but that I didn't have $34,000 sitting in the bank to pay the bond amount.
I understand.
And the lower court did not take that into consideration. Furthermore, the amount of money I told the lower court was government assistance, and the lower court incorrectly calculated as a annual salary or paycheck or annual salary.
Yeah,
Doesn't
that's in your written, those are in your written papers. I have that argument. Okay. So thank you. At this point, I have heard the parties. I will take the matter under advisement and the parties will be notified. Thank you.
Thank you, Your Honor.